So I have many questions, but I'll stick to just two. First of all, you talked about searching for identity. One who is searching for identity, his dignity should be individual dignity should be kept in mind. I have a question regarding it. If we are one searching for dignity, if we are keeping that in mind, should we abolish the concept of illegitimate children? Because illegitimate children are the ones who are searching for their dignity the most. So keeping that in mind, should we abolish the idea of illegitimate children? Because that takes away the identity of a person in ways that we cannot fulfill. Second of all, my question is, when the case of Kushal Kumar versus NAS Foundation came to Supreme Court, do you think Supreme Court missed the chance to uphold the individual dignity and the fundamental rights of citizens of India who are in many ways the most downtrodden?
I can, what's your name?
Your name.
You see, that matter is still pending in review. And sub judice matters we don't discuss. Thank you.
Answer. And in fact, illegitimate word is not recognized in the legal circle. It is more often than not it is used in a social conversation. So probably that usage is just not accepted in a legal context.
Sansaria, a stand was taken by the father that the children are illegitimate. The court found children, because he was trying to tell the marriage is a nullity, the court said we declare the children to be legitimate and we say so. This was the imperative language of the court. And they have all the rights and more rights are flowing. Actually, when a society grows, this identity crisis gets lessened. I can't often say anything, but suffice it to say, with the passage of time, all this concept will gradually get cleared. You see, like we had a concept in Mahabharata, Banna Shankar, that's no more there. In Shakespearean tragedies, you will find all villains are illegitimate. With Shakespeare thought, only those people can do these kind of things. He's a great writer, but many people don't appreciate. A time has come now when you have constitutionally, you have legally accepted legal relationships. You can imagine the further progress.
Sir, as just you told, women has more ability than men. I totally agree with it. But in past 2-3 years, I have been reading women misusing the law, though the laws has been made to protect them. Sir, will there be any law to protect the rights of the men?
You see, as a student, you have put the question. Before you put a question, you must think. Your question must be a legal one. Article 15(4) talks about affirmative legislation in protecting affirmative legislation for women and other categories as mentioned therein. The protective legislations which have been made for women are under the Constitution. Am I clear to you?
Yes, sir.
So therefore you can't say that, sir, when are you going to have law with regard to men? That's the duty of the parliament.
Sir,
Number one. And as you say, there are abuses. You see, because there will be abuses of law, you are right in your own perception, there may be abuses. There are abuses, even the Supreme Court has says with regard to 498A, before you arrest, you take steps under section 41A and A to C, the whole gamut of things under CRPC. That is protection. You see, when I said, I told you very clearly, I am not on the constitutional base. I said, I read a book. I wanted to share with the younger generation how the women are thought of, higher by the man, that particular author. That's not a constitutional perception. There you are, again, you see, when you are hearing a speech, you must understand what is a part of the topic and what is a digression. Am I clear to you? That is, I thought I said that because that you must have the gender sensitivity. You see, it's still in many homes you will find a boy is given more patronage than a girl. So will you say, when will my turn come? It's not that way. Actually, these are social concepts, social facets. You can't say because they are abusing when you are protected. How do you know that male are not protected? Sometimes the courts decline to transfer cases filed by women when they really go overboard. But because there is a convenience concept, there is affirmative legislation. You see, just imagine, when a woman is to be thrown from home, she was neither here nor there. She had lost her home in the parents, she has lost her husband's home. Where was she? And where were you? That is why the Domestic Violence Act, Dowry Prohibition Act, rights of property rights, all that to be created. After we come to a particular level, socially accepted level, then we will talk about. Now, abusers don't make laws, good law, bad. That as a student of law you must understand. Because a law is abused, it's not constitutionally invalid. What you are saying now is some kind of a common feeling which you gather. You come to court, sit down in court someday, what's happening? You see few courts, then you will understand.
A very warm good evening, Your Lordship. I am Satendra Mani Tripathi, a fourth year BLLB student. Just have a query regarding one of your pronounced judgment of May 2014, Bhuvan Ram versus Meena and others, wherein you pronounced that the delay by the family court specifically should not be done at the prior level because it hinders the individual identity of the women concerned. Your Lordship, and the reference of one of your inference, I'm just referring, the caveat which you talked about in one of your portion of your delivering of your speech, that there has to be a balance between both the parties. Your Lordship, in this specific case, what actually happened, that there were certain adjournments were taken by the court, much more time it should have been taken by the court. And your judgment said that there shouldn't be such adjournments. And the reason for the adjournments was because of the lady was not actually presented so many times during the trial, during the proceedings, and later on the judgment was infructuous of the family court. Your Lordship, what's your take on this?
The judgments, I'm not supposed to explain my judgment, but still we'll discuss. You are a student. Does the judgments say that the lady took adjournments?
The judgment doesn't say that. There were certain pleadings from the opposite party as well, but it was a fact that the lady took certain...
Please try to understand.
Yes, sir. Yes, Your Lordship.
No. Why because now thereafter, the Supreme Court has constituted a family court sensitization committee. In all the states, they have been constituted.
Yes, Lordship.
For the purpose that the judges, family court judges, must be sensitized to the matrimonial problems between the couple. It's not that the husband or the wife. You see, we are in which year?
Fourth year, Your Lordship.
Fourth year. If you read the objects and reasons of the Family Courts Act, it's meant to facilitate settlements and early disposal. The job of the family court the duty of the family court judge is to try for a settlement. But what has been happening, as noticed in that judgment and thereon after another judgment, you see, they go on granting time. That was a case which related, my memory serves me right, with regard to grant of interim maintenance under section 125 CRPC.
Yes, Your Lordship, yes, exactly.
The case took so long. You see, it must be seen who is trying to drag the proceeding, how many times. And if both of them can't be trying to drag the proceeding, she needs money, she needs her maintenance, she needs to sustain herself. So therefore the duty of the court was emphasized, because she goes from a level of destitute to a beggar. You never know. You see, every case is not for a pound of flesh from the husband. There are cases, most of the cases are for sustenance. You must appreciate the judgment from that perspective.
All right, Your Lordship. Thank you.
We'll-
Thank you so much, Lord.
We'll now have the next question, please.
Good evening, sir.
Thank
Sir,
you.
it's an honor and privilege to hear your speeches, and I'm standing in front of you. I would like, if you'll answer another subject matter which is related to all India judicial services.
Can we please only have the topic related any queries? Please ask questions related to the deliberation that has been held over here.
Good evening, sir. Is the idea of individual liberty really working out in contemporary India when the state, by its constant actions, clearly suggested that it is working in the favor of majoritarianism? By whether it be misusing Section 66A of IT Act between 2008 and 2015, or the misuse of Section 128A of IPC.
Law is there. When there is abuse of the process of law, one can challenge it under Article 226 of the Constitution or 482 of the Code of Criminal Procedure. Whether there is abuse or not, or case is made out or not, the court shall see on the facts of the case. There can never be a general answer in law. Am I clear to you? Law is always on specifics.
Yes, sir.
And anyway, 66A has already been declared
Ma'am, that's why I
unconstitutional.
mentioned that misuse between 2008 and 2015.
So already sir has told, we are slowly proceeding there. Okay, one last question, I think. Himanshu sir, one from faculty also.
Lordship have mentioned very landmark judgments, Keshwanand Bharti case, Gopalan, and right till Menka Gandhi. And may I ask my Lordship whether today we are maintaining the dignity under the or through the procedures established by law or due process of law? Not due process.
The students are requested to maintain silence. Thank you, sir. That was indeed a very informative session. And on behalf of the students, I would like to thank Honorable Mr. Justice Dipak Misra for being kind enough to be given this opportunity.